So a huge decision striking down a machine gun possession charge as a violation of the Second Amendment is now once again up for review. So let's break down what is happening. Now, really quick before we jump into this video, I just want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed. So if you want to support the channel for free, a great way to do that is simply subscribing. You don't have to subscribe, but it does help the channel. And then also just dropping a positive comment down below. Lets the algorithm know that you appreciate this type of content, and then it helps to push this video and other 2A content out to more people. So a federal court recently dismissed a machine gun possession charge using the Second Amendment and also the Supreme Court's recent decision in Bruin. This is a very significant case. It's a huge win, which again struck down a machine gun possession restriction, and it said that that was a violation of the Second Amendment. There have recently been 2 federal district courts who have dismissed machine gun possession charges and convictions based on a finding that those federal laws as applied to those individuals did in fact violate the Second Amendment. The most recent decision came in a case out of a Mississippi district court, and that was issued by a judge named Carlton Reeves in a case called U.S. versus Brown. However, that ruling in the Brown case cited to a previous case that came just a couple months earlier. In that case, we're going to be talking about is U.S. versus Morgan, and that case is now in front of the 10th Circuit Court of Appeals for a renewed review of this case. And here the federal government is asking for the 10th Circuit to override and dismiss what the lower court said. Now, the facts in this case are that Mr. Tamori Morgan is charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. section 922-0. Specifically here, Mr. Morgan is charged with possessing an Anderson AR-15 that was claimed to be a machine gun, and then also a machine gun conversion device. Simply, he had a Glock switch, so he had 2 different items in his possession, and he was charged based on the possession of those items. On review, the district court judge actually found the defendant here did actually plead a proper Second Amendment challenge, and as applied to him, 18 U.S.C. section 922-0 does not apply. In this case, the judge stated that defendant argues that 18 U.S.C. section 922-0 is unconstitutional facially and as applied to him. Defendant argues that under the first step of Bruin, the plain text of the Second Amendment applies to his conduct of possessing machine guns. The government argues to the contrary, pointing to the language in Heller that suggests the unconstitutionality of machine gun regulation would be startling, and that the Second Amendment only applies to weapons that were commonly used by law-abiding citizens at the time of the Second Amendment's enactment. Here, plaintiff is charged with 2 counts of machine gun possession, and both counts apply to arms that can be carried in the hand. Thus, by definition, the machine gun and Glock switch are bearable arms within the plain text of the Second Amendment. So that was significant because the judge here found that both of these items are bearable arms and per se protected by the plain text of the Second Amendment. When looking at the Supreme Court's precedent in Heller, the court actually found that the government relies on Heller to argue that machine guns are not covered by the plain text of the amendment. The Heller language cited by the government is unavailing. First, the government's interpretation of Heller relies exclusively on dicta, but machine guns were not at issue in Heller. Second, the government's interpretation would run directly counter to the essential analysis in Heller. Just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. So the court here actually rejected the federal government's argument that Heller supports this type of machine gun restriction as applied to Mr. Morgan. The court then looked at the federal government's arguments about Miller. They state that third, the government relies on comments in Heller regarding U.S. versus Miller. Interestingly, over half of the opinion in Miller was devoted to explaining how in the years preceding and immediately following the enactment of the Second Amendment, one of the lawful purposes for which law-abiding citizens possess firearms was service in the militia. The judge then reviewed the federal government's historical analog to see if there was any tradition or history or any type of historical analogs that actually justified this type of restriction. The court found that the government actually did not meet that burden. The judge found that the 2 analogs that were put forward by the federal government do not justify the charges here for the mere possession of a machine gun. The judge stated in his opinion that, to summarize, in this case, the government has not met its burden under Bruin and Rahimi to demonstrate through historical analogs that regulation of weapons at issue in this case are consistent with the nation's history of firearms regulations. Indeed, the government has barely tried to meet that burden, and the Supreme Court has indicated that the Bruin analysis is not merely a suggestion. Now, it's important to note that in this Morgan case, the federal government put forward very little evidence and very little historical arguments to try and justify this type of federal law. Instead, it seemed like they kind of got lazy. They thought the analysis here by the court wouldn't even really make it past the plain text aspect of the case. They thought maybe that the court here would say these are not bearable arms. But once this got past, the bearable arms aspect, the federal government didn't put forward a lot of evidence, and therefore they pretty much lost automatically. Well, after losing in the district court level, the federal government has now decided to appeal up to the 10th Circuit, and they're asking for the 10th Circuit to reverse what the lower court judge said. They ultimately want the 10th Circuit to find that machine guns are not bearable arms, they're not protected by the plain text of the Second Amendment, and they now argue that they have historical justifications for this type of restriction. Mr. Morgan has filed his response to the 10th Circuit, and they argue that the narrow decision by the district court should be upheld by the 10th Circuit. In the beginning of his brief, Mr. Morgan's attorney points out that the federal government here in this case in front of the 10th Circuit is now kind of trying to pull a fast one. They are bringing new arguments on appeal that were not raised at the lower court level. Also, now they are trying to smuggle in some new historical arguments and new pieces of evidence that they did not bring in the original challenge. Instead, in front of the district court, like I mentioned, they only put forward 2 historical arguments, but now they're trying to add more on appeal. Mr. Morgan's attorney argues that the 10th Circuit should reject and ultimately just outright ignore all the new historical examples since they were not in front of the district court on the record, and the job here at the 10th Circuit is to review whether or not the district court committed a reversible error. Mr. Morgan states in his arguments that on the threshold question, this court should affirm the district court's straightforward plain text analysis. The Second Amendment presumptively protects all arms that constitute bearable arms, including modern instruments that facilitate armed self-defense. The machine guns at issue here are arms that can be carried in the hand to facilitate armed self-defense and thus are presumptively protected by the Second Amendment. The government does not dispute this straightforward analysis. It instead turns from the Second Amendment's actual plain text to the Second Amendment's history and claims that the handheld machine guns are not arms under the Second Amendment simply because they are not typically possessed or in common use for lawful purposes today. As explained below, the government has forfeited this legal theory because it did not raise it below, and it has further waived its new legal theory because it has not complied with the 10th Circuit's Rule 28.1a or argued plain error on appeal. They go on to state that the ultimate question to meet its burden to justify Section 922.01's prohibition on the possession of Morgan's handheld machine guns, the government relied on only 2 historical sources. On appeal, however, the government relies on an array of historical laws numbering in the triple digits. This court should limit its review to the historical record compiled below. So one of the main thrusts made by Mr. Morgan to the 10th Circuit is that the district court came to the correct conclusion, especially based on the limited evidence presented by the federal government. The federal government does not now get to just supplement its arguments. Instead, the 10th Circuit should only review whether or not the district court got the decision correct based on what was presented to them down below on review. Also, they emphasize that this is a very narrow decision applying only to Mr. Morgan and the facts of his case. This is an as-applied challenge, and this section of federal law was found unconstitutional as it applies to Mr. Morgan. The district court did not close the door on other cases or other facts coming out in a different way. So they said like maybe in a different case, and if the federal government argued it in a different way in another case, it could come out a different way. But you don't get to supplement that stuff now. You don't get to change everything now. The decision by the district court was very narrow as it applied to Mr. Morgan on the specific arguments that were made by the federal government. So this is a big decision now being considered by the 10th Circuit. Mr. Morgan has, I believe, a very strong case, especially since the federal government kind of botched the case at the lower court level. So we're now going to be watching this appeal closely to see what the 10th Circuit does, how they're going to handle this. Maybe they're going to let the federal government get away with some stuff. I don't know. Maybe they're going to let them get that additional evidence in. Now, one of the also interesting things about this is, Pam Bondi and the Trump administration now having control of this case. And it's going to be interesting to see how they proceed forward this once they have full control of the challenge. So again, we're going to be watching this closely. As things change, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.